All right. Hey, everybody. So this is going to be my first attempt at trying to do one of these flipped classroom lectures. So the idea here is that you're going to be able to follow along at home at your own speed. You can stop, play, pause, do whatever you need to do to the video. You should have a guide for the sort of questions I'm going to be looking for you to answer. And I'm going to try to fly through it so that you can go through it at your own pace later. Alright, so first of all, it's chapter 4 on the civil liberties. Next time, we're going to be talking about civil rights. They're very much related, and it's all part of the judiciary. So the first concept I want to talk about is just what civil liberties are. And they're the personal freedoms that are protected for all individuals. And they're typically concepts or laws that involve the restriction of the government to act against individuals in that government, or in that citizens of that government. Now, originally, it's important to note that the 14th Amendment rights were actually given after World War, or the Civil War. Therefore, the idea of the Bill of Rights and those civil liberties involved weren't actually incorporated into the law until after the Civil War. Before that, if you think about your First Amendment freedoms, they actually only pertain to federal law. They didn't pertain to state laws. Therefore, it took a process known as incorporation, where the states themselves actually had to vote to, or had to, through their case law and voting and amending their state constitutions, actually incorporate due process and the 14th Amendment laws into their own states. So that process of applying civil liberties to the states is known as incorporation, and it all stems out of the 14th Amendment. And then the last case law issue that we're going to look at for that is Gitlow versus New York, 1925. During that case, it was the first time that the Supreme Court actually established that the 14th Amendment rights were going to be applied to the states. Now, looking at the freedom of religion, we've talked a little bit about the Establishment Clause and the Free Exercise Clause, but we haven't talked too much. The main points that I want you to recognize are that as part of the Constitution, the Establishment Clause prohibits the national government from favoring a certain religion over another. I'll say it again. It prohibits the national government from favoring a certain religion over another. Now, that's important because we also have the Free Exercise Clause, which basically says the national government can't constrain any form of religion from being prohibited or influenced as a result of the government. So those two clauses at times can actually run contrary. So at times when we prohibit one religion from being favored, it might actually limit in turn, in a sense, it might limit that religion from being given. So at times we're going to see how that becomes an issue. And again, when we do our mock Supreme Court, it'll come up. Now the big Supreme Court case that we need to know when we think of the establishment of religion is Lemon versus Kurtzman, 1971. This case was brought before the Supreme Court, and what came out of it was the idea of the Lemon test. The Lemon test is used to, anytime there's an issue over religion and the Establishment Clause, the precedent was set that the courts would then use this three-step Lemon test to gauge whether or not a law is entangled in the establishment of a religion. So those points are, one, is as a result of the law, the fact is that the aid has to be secular in nature, it cannot prohibit or advance religion, and it has to avoid excessive government entanglement with religion. So those 3 points will always be looked at in cases where religion is involved. So after this, after 1971, the Lemon versus Kurtzman, a lot of cases have come up in a lot of different subject areas. One is Aguilar versus Felton, which just was related to the voucher money that was given to the public school system to pay for students to actually go to religious private schools. And originally it was said that that money was actually a violation of the Establishment Clause. Later, that same case went to the Supreme Court 12 years later, and they decided it didn't violate the Establishment Clause because students could use that voucher money to either go to a private religious school, but there was also the option of going to other private schools that weren't religious in orientation. So because of that, they ruled later it didn't violate it. It wasn't violated. It was something that the Lemon Test actually passed. Again, that comes up Engel versus Vitale, 1962. This was before they had the Lemon versus Kurtzman, the Lemon Test. But in that, they said that school prayer, the forced, so they actually were forcing students to say a prayer before every school day. They said that went against the Establishment Clause. Again, this came up over and over, and they kept holding that you couldn't establish one form of government in a public space. Now, the freedom of expression. Some things I want to point out about that. I want you to recognize the concept of prior restraint. So, in our Constitution, we can't actually restrain an act from happening based on presumptions. You know, we can't arrest you before you commit a crime necessarily. And with expression especially, that comes up. So if it looks like you want to give a speech, or if you're trying to express yourself in some way, the government can't censor you to do that. And in any case where it seems like expression is being denied, the Supreme Court overwhelmingly tends to rule in favor of the person because they view the Constitution as upholding the idea of having no prior restraint. Now, other issues that you have to include when you think of expression are more than just speeches, but this idea of symbolic speech. So, can you be restricted from wearing certain articles of clothing? Can you be restricted from making gestures or movements and other non-written forms of expression? Well, we're going to look into, when we do our mock Supreme Court, some cases where that comes up in the schools, and we'll see where the law holds on that. Now, the idea of commercial speech, that's just saying what the government can and can't limit as far as business forms of speech through advertising. And the Supreme Court, as of late, tends to rule in favor of business. They don't want to limit what businesses advertise as long as what they're advertising is accurate, as true, as long as they're not putting up falsities in front of the public. Now, these last two ideas on the freedom of expression that I want to cover are the clear and present danger and the incitement test. So both of these are in reference to how the Supreme Court and laws will be viewed when an issue of danger comes up. So if you're expressing yourself in such a way that it presents the inevitability of there being some sort of act that does harm to the public or the government, if they can prove that there's clear and present danger posed to enact some sort of issue or danger to the public, in that case, then the government, the police, they can step in and arrest someone if they can prove that they're enticing some sort of violence. And that goes along with the incitement test. So if it can be proved that a person is inciting the masses to commit danger against the public or even against themselves, then the police can act to prevent that. Now, another form of expression that can be restricted is obscenity. And I want to use this case, Miller versus California, 1973, to describe what obscenity is, because it's a rather vague idea. The courts have ruled that they can restrict people in situations of being obscene, but their definition for obscene is vague. And what they've said it is that they set up a rule saying something is obscene if, one, the average person finds that it violates contemporary community standards, two, the work taken as a whole appeals to a prurient interest in sex, three, the work shows patently offensive sexual conduct, and lastly, four, the work lacks serious redeeming literary, artistic, political, or scientific merit. So ask yourselves, guys, does this seem like a clear definition? Because in my mind and in the court's mind, it isn't very clear. What it's saying is that pretty much it's going to leave it up to the standards of the community, or in that case, the standards of the jury. So if the jury holds something to be obscene, then that's what the courts are going to rule on. So this obscenity law or rule is been used in a large spectrum of cases and ruled very differently in different cases, which has presented a lot of problems for the Supreme Court. Now, the last 2 points I want to note are concepts that I know we've talked about and that you've seen, but one is the idea of slander, and this comes up in civil court mostly. But you can't say something, you can't utter a falsity about someone that causes harm to them. If somebody accrues some sort of harm as a result of something you said in a public forum, that could be over the radio, or as a teacher saying it in school, or your boss saying something over a company-wide email, well, in that case, then they've committed slander against you. You can take them to court. Now, libel goes along with that. It's the same thing, but it's different from using your voice to publicly utter something. In this case, it's writing something. So if you publish a book or a newspaper article or a magazine article, and what you say is inaccurate, and as a result of that inaccuracy, then a group or a person suffers some sort of harm, in that case, then you have committed libel, and you could be called to a court. Now, I also want to talk about this idea of right to privacy, because the right to privacy is nowhere exclusively said you have the right to in the Constitution. It does not hold its own First Amendment right. However, in 1965 in Griswold versus Connecticut, the Supreme Court ruled that the use of contraceptives by females is a protected right guaranteed to them through their right to privacy. So they can't be denied access to contraceptives because they are guaranteed privacy. And that privacy should be between the person and their doctor. Now, the way that the Supreme Court justices describe that is that they claim the First, Third, Fifth, and Ninth Amendments created the basis for guaranteeing privacy rights. In other words, although they didn't exclusively say privacy, they, in essence, created the justification for there being a right to privacy. They're kind of, without saying it, they cast a shadow over that right, which has been interpreted by the Supreme Court to be a right guaranteed to them. And again, this comes up in Roe v. Wade, 1973, when the right to an abortion was seen as a privacy right and therefore guaranteed. Now, the last points I want us to look at are what we call the Great Balancing Act between the rights of the accused versus the rights of society. This chart I want us to look at, and I'm going to allow you time to pause and answer the questions on it. But this will be what you use to to determine the limits of conduct of police, the rights of a defendant, and then the trial rights. And you can see where those amendments have been enacted and upheld in the Supreme Court. So you could pause here if you'd like to look at this. Now, the last thing I want to talk about are the Miranda rights. So in a case in Miranda versus Arizona, it actually came up that a person was actually guilty of raping and killing a girl, but because he was denied the right to be silent, he was never told he exclusively had that right, his lawyers argued and he was actually able to be set free. And that led to the establishment of what are now known as Miranda rights, which I think you should all be familiar with, whether through television or your own personal experience. And those are the right to remain silent, and that any statement may be used against you in the court of law, and you have the right to an attorney. Now, those rights are read whenever somebody is arrested as a result of that case, Miranda versus Arizona. And they guarantee that a person knows their rights before they are interrogated. And the last thing I want to say is the exclusionary rule, which forbids the admission of trial or in trial of any illegally seized evidence. So that means that if a police officer or a federal officer finds a piece of evidence in your house or on you, but he obtains that illegally, if they obtain a piece of evidence, no matter how they get it illegally, and no matter how damning that evidence could be in your trial, if it's found illegally, then as a result of the exclusionary rule, it will be thrown out of the court of law and not used. And then a lot of times the Supreme Court looks at whether or not something was obtained legally or not, and whether it therefore can be used. All right, thanks guys. I hope you enjoyed your snow day.